Good morning. Welcome to another episode on labor laws, employment laws in my channel, and I would like to address the pressing issue raised by some of those who make comments by sending me email, message, and the comment involves a question on why some employees are not entitled to labor standards benefits. The commenter is actually referring to a supervisor or manager who is not entitled to overtime pay, not entitled to holiday pay. Now, the basis of that is Article 82 of the Labor Code, which provides for exclusion of certain employees from benefits, such as those involving the hours of work, the holiday pay, the service incentive leave, so on and so forth. So this video is catered more for HR practitioners, business owners, managers, expats, even to guide them on the basic inclusion of benefits under our labor code and those who are excluded. Now, the difference between these two is crucial because the companies don't want to be overpaying the benefits to individuals or employees who are not really entitled to it, and don't want to make a mistake of not giving benefits to those who are actually entitled. So this is a little bit more technical in a way, but which is very important in understanding the labor laws under the labor code. So why do I say labor laws under the labor code? Because we have other labor laws which are not part of the labor code. For instance, the 13th month pay law, or the PD 851, as amended by Memorandum Order number 28. And now these benefits also follow the inclusion-exclusion rules of certain individuals or employees whose status exclude them from availing these benefits. Now, in my next discussion, I will be referring to my PowerPoint slide, and based on the recorded screen that I will have in my laptop. So I will shift your view to my screen, and here I will start the discussion on the question, to whom do labor standards apply? Now, the application of labor standards benefits. Article 82 of the Labor Code states that the provisions of this title shall apply to employees in all establishments and undertakings, whether for profit or not. So basically, this is the general rule, which means that it applies to anyone. It applies to all employees where there's employer-employee relationship. So it doesn't matter if the establishment is for profit or not for profit, as long as there's such a relationship, which is the employer-employee relationship. Now, the title referred to here pertains to working conditions and rest periods found in the Labor Code, which span from Article 82 to 96. And it covers 3 chapters. The chapter 1 refers to hours of work. So hours of work, of course, covers the rules on employees timing in or logging in to come to work every day. The rule when they work in excess of 8 hours or the overtime, and the rules on undertime. And then chapter 2 referring to weekly rest periods, and chapter 3 holidays, service incentive leaves, and the service charges. So take note, we now have a new rule on service charges, wherein the split before of 85-15 was changed or amended by Congress, making it now 100% service charge is given to employees and no more share for the management. Now, what is the list of labor standards benefits under the labor code? I have here, first, the normal hours of work found in Article 83, the hours worked under Article 84. You have meal periods under Article 85. Basically, meal periods, the lunch break that we implement in the company or establishment. The night shift differential for those working from 10 p.m. to 6 a.m. That's found in Article 86. And the overtime work, which is basically work in excess of 8 hours, that's Article 87. And the rule on undertime that cannot be offset by overtime. This principle is very simple. The overtime usually has an additional pay of either 25% or 30%, as the case may be, depending on whether the day that the employee rendered overtime falls on a regular day, in which case the 25% applies. And if not, like it's holiday, it's rest day, the 30% applies. Now, this cannot be offset by undertime taken by the employee, because that undertime usually happens in a regular working day. So there's no additional 25% or 30%. So in a manner of speaking, we're going to just allow offsetting because the employee would be at a disadvantage, being deprived of the overtime, which is 25% or 30%, and in exchange of that is the payment in the form of regular working day. So it's a loss of 25 to 30% in terms of pay. Now we have the emergency overtime work. Basically, this Article 89 providing rules when employers may require or compel employees to come to work to render overtime. So any employee who refuses to work when ordered under this provision or article can be held liable for insubordination. And we have under Article 90, computation of additional compensation. So basically, we're actually discussing here the overtime pay and the premium. And then we have right to weekly rest period under Article 91. So highlight in this provision is that one rest day per 7 days after 6 days of work. Okay. So the default rest day in the Philippines is Sunday, although there are employees who may request for a different day like Saturday for religious reasons. So we have rules on that, which I will cover in my next video. And then when employer may require work on a rest day, that's Article 92. Basically, it's the same principle found in Article 89. Compensation for rest day, Sunday, or holiday work under Article 93. The right to holiday pay, Article 94. And the right to service incentive leave, or SIL, under Article 95. And finally, the service charges I mentioned under Article 96. Now, who are excluded from these labor standards benefits? They have no application to the following. Number one, government employees. Why? What rules govern government employees? They are governed by the civil service rules. And as the government office or company is a GOCC, or government owned and controlled corporation, organized under the corporation code, or those registered with SEC, then they can be governed by the labor code. Now, these benefits that we mentioned have no application to managerial employees or the other officers or members of the managerial staff. So this is where the supervisors, the managers come in. When we say the managers are not covered by overtime rule, the managers are not covered by the holiday pay, so on and so forth. And then we have the field personnel, those who work away from the office, and the time spent at work cannot be determined with reasonable certainty. Okay, field personnel. So you have your med rep, for example, or salespersons. Number 5, members of the family of the employer who are dependent on him for support. No application of labor code in that case, the domestic helpers, because they are now governed by RA 10361 or the Batas Kasambahay law. And number 7, persons in the personal service of another, they are not governed. So the drivers, the yaya, they are not covered by the labor code. Okay. And workers who are paid by results as determined by the Secretary of Labor in appropriate regulations. Now, who are these managerial employees? And what is the distinction between the definition under Article 82 and Article 219 of the Labor Code? So, in the Labor Code, there are two sets of definition of managerial employees. One is found under Article 82 and another one is found under Article 219M. So, what's the difference? Article 82, the definition that we mentioned a while ago, pertains to availment of labor standards benefits. So, it was defined for the purpose of telling employers and employees which kind or type of employees is or are covered by the labor standards benefits. Now, managerial employees, these are the rules. The law says that number 1, to know when the individual is a managerial employee, the primary duty consists of the management of the establishment in which he is employed or of a department or subdivision thereof. Number 2, he customarily and regularly directs the work of 2 or more employees therein. So basically, he is managing somebody, delegating his work, being a manager. And he has the authority to hire or fire employees of lower rank, or their suggestions or recommendations as to hiring and firing, and as to the promotion or any other change of status of other employees are given particular weight. Now, the rule says that only when managerial employees meet the above conditions that they are excluded from all the benefits mentioned under Articles 83 to 96. If some of those conditions are not met, then they can be considered as rank and file employees and should be given the benefits mentioned. Exception, however, is if he and his employer had agreed on it. So, there are companies wherein even managers who are not or supposedly not entitled to labor standards benefits, the company and that manager may agree that he will be covered anyway. For example, PD 851 or the 13th month pay law, it excludes managers from such benefit. They are not entitled to 13th month pay. However, there are companies who are giving 13th month pay even to their managers. And that comes within this exception. If they have agreed on it, there's a practice that's duly recognized inside the company, and it's not just a mistake on the part of the employer. Another is the definition of other officers and members of the managerial staff. So the previous rules, guidelines that we discussed pertain to the managerial employee. And this time, we are giving the rules or qualifications for one to become other officers and members of managerial staff. So what's the difference? So the managerial employees basically are the managers, and the other officers and members of the managerial staff can be the supervisors. So the supervisors are not entitled to the labor standards benefits that we mentioned, just like that of the managerial employee, provided that the conditions are satisfied. And these conditions are, number 1, the primary duty of such other officer or member of the managerial staff consists of the performance of work directly related to management policies of their employer. Number 2, they customarily and regularly exercise discretion and independent judgment. And 3, they also, now we have here the sub bullets. 1, regularly and directly assist a proprietor or a managerial employee whose primary duty consists of the management. Number 2, execute under general supervision work along specialized or technical lines. Execute special assignments and tasks, and they do not devote more than 20% of their hours work in a work week to activities which are not directly related and closely related to the performance of the work mentioned. Now, as I said, the difference between Article 82 and 219M, which was formerly 212M under the Labor Code, in Article 82 of the Labor Code, both the managerial employees and other officers and members of the managerial staff, like the supervisor, they are lumped together to exclude them from labor standards benefits. However, in Article 219M, there is a different definition for managerial employees and a different definition of supervisors, to mean that since Article 219 is under the labor relations the chapter or the unionism, it says that managers cannot join and form a union. However, the supervisors can join and form a union, but only union of the supervisors because they cannot join the union of rank and file. So this is the difference. The labor code split the managerial employee and the supervisors under Article 219, but merged them in Article 82 for purposes of labor standards benefits exclusion. So now, if I have to present to you a table on the exclusion rules, just to give you a quick view on who are excluded, who are not, well, this is it. The first column, type of worker, we have the government, the managerial, other members of managerial staff, domestic workers, so on and so forth. You can read this from the screen. Now, they are excluded from night shift differential, etc., the holiday pay, the service incentive leave. So these are the basic benefits mentioned in the labor code provisions that I discussed. So take note of the field personnel. If these employees are supervised, they become covered by the benefits. So the fact that they are field personnel, they're not supposed to be supervised, and when the supervision comes in, then they lose their status as excluded employees from said benefits. So I hope you learned something from this video, and this is very important because this is the backbone of understanding the benefits under the labor code. So with that, stay safe, guys. We're still under quarantine, and wear mask when you're outside your residence, and of course always wash your hands and bring alcohol. So see you in my next video.